Okay, I've opened the webinar, so people should be able to join at any point.
Welcome everyone to Select Path's webinar, Tackling HR in Our Post-COVID World of Work. Let's get ready together. It's great to see so many clients out to this session. For those of you who are not clients of Select Path, we're also happy to have you with us today. We have scheduled a presentation for an hour and 15 minutes. This will allow for time at the end of the presentation to ask Nick your questions. Please use the chat feature to pose your questions. The presentation will be made available on our client resource site, available through our website. For those of you who are new to Select Path, our firm is based in London, Ontario, with offices in Sarnia, and is one of Canada's largest employee benefit, group retirement, financial planning, wealth management, and scalable HR consulting firms. Our firm helps more than 1,500 organizations and over 3,000 individual clients, managing more than $500 million of employee benefit premiums and $450 million of investment assets. Select Path's highly credentialed staff provide our clients the support to help achieve their right path to success. Recently, Select Path joined the Navicord network. By joining Navicord, Select Path has increased its capacity and capabilities to meet the growing needs of our clientele. Founded in 2014 and headquartered in Toronto, Navicord is one of Canada's top 5 commercial insurance brokerages and a leader in risk management services with $2 billion in premiums. Navicord partners with clients to deliver the trusted advice, expertise, and custom insurance solutions organizations and individuals need to face the future with confidence. Now, without further ado, it is my pleasure to introduce our presenter, Nick Preston from Leclerc & Associates. Nick is a South African qualified lawyer with a decade-long career representing employers in labor and employment-related disputes. Now living and working in London, Ontario, Nick has since completed his conversion exams and written the Ontario Bar exam while continuing his legal career at the firm Leclerc & Associates. Leclerc & Associates focus solely on management side labor and employment issues, especially the impact that the COVID-19 pandemic has had on the workplace. Nick, take it away.
Thanks so much, Gord, and thank you to your team and to Select Path for having me this morning. It's always exciting to talk about COVID. It's something that's run for most of this year, and 2020 is certainly one that's going to go down in history, that's for sure. I think that the webinar is quite timely that we have it at this point in time. Obviously, as we move through each and every week, there's new developments and so forth. But just this past weekend, we saw again the greatest spike that we've seen in COVID-19 cases in Ontario since the middle of April. And already there's certain talks around a second wave. So as we move through the various phases of returning to work and what that looks like under the COVID-19 regime, it's probably a good time to just reflect on where we've come from and what we've experienced, and then looking to the future and how we build flexibility back into our businesses. Certainly in the world of HR, and as an employment and labor lawyer as well, this area of law probably received the biggest impact when the COVID-19 pandemic hit. If you have a look at commercial transactions and a whole lot of other areas of law and practice out there in business, none of them were quite as affected as this space, which makes it quite relevant for ourselves and as professionals moving forward. I wanted to move through, let me just get these slides to work. Effectively where we've come from and what HR and employment law look like for us just before the pandemic hit. And it kind of felt like we had received all the trophies. We knew where we were. And toward the end of 19, most of the Oscars had been won. Sure, there were marginal changes year on year, but for the better part, we had seen it all. Our contracts of employment and our templates were pretty much refined. We had the whole suite of policies that one could wish for in any company. And, things like layoffs and those sorts of things really only happened in unionized environments. Unfortunately, in October last year, I presented at a seminar, and the question was asked, how many companies have started thinking about flexibility within their workplace, and in particular, work from home type arrangements? And most people in the room put up their hands. And then the second question was, how many of your companies have looked to actually implement work from home and flexible work arrangements? And about 2/3 of the room's hands went down. And it's quite interesting because since COVID-19, if I ask the question again, it's a pity that we're not all together this morning, but I'm sure that most people's hands would be going up now. So it just shows the change and the dynamic that this has brought to us in our new world of work and how we move through things. So I thought the first focal point may be this morning where we've been. And effectively, when the pandemic hit, we had the list come out of essential and non-essential businesses. And work from home is almost the natural starting point because that was the immediate reaction. It almost became a means of survival for many businesses. And accepting that work from home doesn't lend itself to all environments, in particular manufacturing and engineering and those sorts of things. But for those businesses that can use work from home, whether you were ready or not, you were forced into that mold. We also saw a flurry of temporary layoffs being implemented across the board, not only in union environments, which was typically what we've seen over past years, but every environment. Employers were looking at whether this was a necessary option that they needed to take. And the only constant throughout 2020 has really been one of change. And that seems to be something that's going to continue into the future. So I think that the first major trend that I just wanted to identify, and it's almost an underlying theme for the entire webinar, is just building flexibility into our businesses and being resilient, as we move forward and through this pandemic to the future. And with the talks of a second wave coming now, I wanted to share probably some insights and some of our experiences on how we build this flexibility into our business. And we'd like to share some of those documents with you, and perhaps we can just share those with the Select Path team, and they can distribute that onto you, just as resources to make your lives, I suppose, easier and more flexible as we move through things. So I thought we could first start off with temporary layoffs and what the world of work looked like. For those of you that have been to Paris, you'll know that that's the Arc de Triomphe, I believe it's called. And I've never seen it that empty. And I don't think Paris has seen it that empty, but that was really the reality of what the pandemic looked like. And I think it's important as a starting point that employment law was never drafted for the global shutdown that we've just experienced. So we saw a lot of developments and a lot of news. And even this morning, there was some more information that's come through, which I'll share with you shortly, on changes to regulations and laws as we apply them within Ontario and in Canada. So just to share with you some statistics first as we get into temporary layoffs. More than half of Canadian households were affected by temporary layoffs in some way or form. And 1 in 5 businesses reported that they had more than 80% of their staff on a temporary layoff at some point in time during the COVID-19 pandemic. So that's just really the impact and the gravity that the pandemic had on this area of law and in the areas that we sort of practice and work within. So just dealing with the law briefly around temporary layoffs and without making it a legal lecture, effectively at common law, temporary layoffs are not permitted. But the Employment Standards Act provides us with a saving provision. And the saving provision avoids triggering the deemed termination provision. So effectively, if there is a layoff, you're entitled to lay off staff for a period of up to 13 weeks in any 20-week period, and for a period of up to 35 weeks in any 52-week period, provided there's benefit continuation or some other payment. But the common law also requires that there be an agreement around layoffs, some sort of permissive wording that allows the employer to lay off staff in the first place. And outside of most union environments, typically that wording is just not found in contracts of employment because one's never really needed to rely upon those. So without that permissive wording at common law, if staff were laid off, and I've shared some of the stats with you so you can see for yourselves how wide that was, there was the risk of a constructive dismissal where employees would say, my contract doesn't provide for you to lay me off. There's no collective agreement in our particular business or sector, and therefore that constitutes a constructive dismissal. So at the point where businesses were being shut down on a compulsory basis by the government for good reason, employers were turning to the layoff provisions under the Employment Standards Act, which if you read them in isolation, surely give license to implementing a layoff, but one needs to have a look at the common law position as well. So there was a lot of noise around the potential risks that may flow to employers following the pandemic, and that if you had resorted to a layoff that you may face these constructive dismissal claims. And then what happened is that we had Regulation 228 of 20 that came in, and that introduced the concept of infectious disease emergency leave. It's commonly referred to as IDLE as the acronym, and it's a form of job protected but unpaid leave. And effectively, what this regulation did is it converted the layoffs that occurred during the COVID-19 period into this infectious disease emergency leave, which brought about a couple of protections for employers. And I just want to maybe pause at this point just to mention that Regulation 228 did not apply to unionized environments. So this would obviously only apply to environments where there's no union or collective bargaining structure. And effectively, the benefits that were brought upon by this regulation is that no longer were the layoffs subject to those time limits that I've just shared with you. So if you had a layoff that continued beyond those time limits, you didn't trigger the deemed termination provisions under the Employment Standards Act. And beyond that, it no longer constituted a constructive dismissal. But that protection didn't continue indefinitely. It was linked to the COVID-19 period, which is a defined period that we find in the regulations. And effectively, we now know that that COVID-19 period ran from March 1 until September 4. So if you had layoffs, temporary layoffs that were implemented during that period of time, they didn't constitute constructive dismissal and you weren't subject to the time limits. So that was a sigh of relief for many employers. But about a week or two ago, the deadline was approaching. We were fast getting up to September 4 and there was a bit of panic. And we spoke to many employers out there about this, and there were mixed views as to what they would be doing. Some employers started looking at effecting permanent layoffs and letting staff go. The issue around that is once you run that over the number of people that were on a layoff, obviously it becomes quite expensive because termination pay becomes payable. And in other respects, you had employees who were being recalled to work to avoid this sort of approaching day of September 4, but were unwilling to come back to work because the employer couldn't offer them full hours again. And quite frankly, they were making more money under the CERB, which was paying around $2,000 per month. So if you say to me, you've been on a layoff, Nick, we're happy to have you back and please come to work, but we can only have you on a Tuesday and a Thursday, that may not be worth my while financially, and a lot of employees started pushing back on that. So we had a bit of a conundrum as to where we were going and these mixed emotions, and there was certainly some noise out there as to D-Day being September 4, fast approaching, and then almost as, you know, just a wish and a hope, on the afternoon of September 3rd, there was an update that was announced by the provincial government where they effectively said that they would be extending this COVID-19 period, which will now run until January 2, 2021. So those protections that I've just mentioned, if you've got staff on layoff and you've missed the deadline and you didn't have wording in your contract and you've exceeded the time periods under the Employment Standards Act, it still qualifies as infectious disease emergency leave, and it will continue to do so until January 2, 2021. So those protections are in place, and certainly a feather in the cap for most employers, just to help yourselves get over the hurdle of this difficult time period and this difficult year. So looking now as to how we build some flexibility into our workplaces and concentrating on layoffs, because that's what we're discussing for the time being. I think that the most important thing to have a look at doing is to future-proof our contracts of employment. So to make sure that going forward for all new contracts of employment, we ensure that we've got wording around layoffs going forward. And again, I'm happy to share those clauses with the team at SelectPath, and perhaps they can pass them on to you. It's just something that we're prepared to give and help employers out there. But ideally, one would want to see all new contracts of employment having layoff language clauses in them, so that in future, if we have a second wave or a third wave, who knows where we get, and layoffs need to be resorted to, that employers are at least covered from a constructive dismissal perspective, because the permissive language is in there. Obviously, one may still be bound into the time periods under the Employment Standards Act. It becomes a little bit more tricky when dealing with existing employees and how to get that language into their contracts. In brief terms, it may require that there be further consideration or something of value that's passed to those employees in order to agree to an addendum to their contract or an amendment where these clauses are added. And one can look at different ways of doing that financially or otherwise. There were then a couple of other issues around recall. So staff that were on temporary layoff, and this is probably going to rear its head even going forward, even though we've got the protection until January 2, on how we recall staff from a temporary layoff. And I think that the one aspect to be cautious about is to avoid any inadvertent discrimination. So for instance, if scheduling X to work, you're doing so because X doesn't necessarily have family obligations, that may prejudice Y who does. So inadvertently, it makes sense that you would want to bring people back who have the ability to come back and to work 5 days a week, whether schools were open or not. That's now at least something behind us. Most schools, I believe, have opened and daycare facilities. But that may be an inadvertent type of discrimination. So maybe just to be alive and I suppose conscious around the family status issues as we move through these sorts of things around layoffs and recall and so forth. And importantly, or interestingly, this morning we discovered that if one has a look at Bill 186, which is the bill that gave rise to this infectious disease emergency leave, and effectively it gives employees the opportunity to remain home in order to look after children. It's an unpaid job protected leave. But owing to daycare closures and school closures, there's now an addition, if one has a look at the Government of Ontario's website under the Employment Standards Act, where it says that employees will now qualify for idle or infectious disease emergency leave, even if they choose or elect to keep their children home out of fear of their children contracting COVID-19. Now, that does seem to be a bit of a shift from what we've seen before, where you couldn't take elective steps in order to confer a benefit upon yourself. Here it appears that there seems to be a move under the legislation that one can now electively decide that I'm not going to run the risk of sending my kids to school. I believe that they may become exposed to COVID-19, so I'm going to keep them at home. By keeping them at home, they require parental care and therefore I can't return to the workplace. So this is a brand new issue that sort of come up in the last day or so, and how one works through those types of issues. And again, looking at accommodations and work from home arrangements, one will have to move through the various options that are available to us. Hopefully there are some. It's really a case-by-case basis, and we're prepared to help with that if any of you get stuck. And then on the federal sector, for those of you who operate in the federal sector under the Canada Labour Code, just around layoffs, there was a 3-month period on which you could lay off staff. That was extended by a further 6 months if the layoff occurred prior to March 31, and to December 30, 2020, if the layoff was between March 31 and September 30. So again, we've seen similar sort of protections and extensions there if you've got layoffs in the federal sector, you're similarly protected and covered. The other issue that I thought was just interesting around the amendments to the regulations and the whole idle issue is that if an employee seeks to fall under infectious disease emergency leave, this form of job protected leave, which is unpaid, in some cases, an employee may be required to exercise that type of leave because they're under a medical investigation, or they're required to self-isolate, having traveled or been exposed to COVID-19. And the regulation also speaks to the fact that it's not permissible for employers to seek a medical note in those circumstances. What it does, however, say is that the employer can seek evidence that's reasonable in the circumstances. Unfortunately, the courts have been closed for the last few months. They have now started to reopen and time periods have kicked in again. But one will have to see how this is going to be interpreted by the courts. What would be reasonable evidence in the circumstances? And I suppose you could apply that to the various instances under which you could exercise idle, which is effectively needing to care for any family member or children as a result of daycare closures and schools, and now this elective type idle, where just out of preference you decide to keep your children at home. And then really the last point around layoffs and recall is the issues around job abandonment. We're certainly seeing a trend. Fortunately, it's small, but it's definitely out there, and where employers are recalling their staff back to the workplace, but they just can't get hold of them. Now, I'm not too sure whether staff have moved on or whether they've secured alternative employment, but one may look to some sort of job abandonment type process in those circumstances. And again, obviously just building a sufficient paper trail and making sure that we communicate as adequately and as widely as possible with those staff members. And eventually, I suppose, putting them on terms that if they don't return by a particular date, and if we don't hear from them by a particular date, we'll be forced to consider them to have abandoned their jobs and positions. So that's just something else around recall. So another thing that I wanted to share with everyone, just before we get into the work from home type arrangements, and I thought that this was a pretty good tweet that I picked up online, and there was an article with it and so forth. But this picture is Rachel Mushua. She's an executive at Intel. Most of you will know it. It's a big IT corporation. And she made this tweet in the middle of the pandemic. And most of you can read it there for yourself. But for those of you that can't, it says, my 14-year-old is taking French class in bed. My 12-year-old is asking for food I don't have. My 10-year-old is refusing to read. And my 8-year-old is in my lap while on calls learning to multitask. This is what it really looks like. Work from home with kids, COVID-19. Those of you who've had to work from home over the past few months, those of you who have kids, pets, whatever it may be, I'm sure that you can sympathize with both the image and the sentiment that's conveyed in this message. And interestingly, if one has a look at the statistics over the COVID-19 period and really assesses this whole work from home arrangement to see whether it's something that one should continue or whether it's something one should adapt or move away from, it's clear that the always-on work culture that we live with certainly reached new heights during the COVID-19 pandemic. And again, for those of us who could work from home, accepting that it doesn't apply to all instances. And just some of the numbers again, work server traffic was up on average by an additional 3 hours per day. And there were surges in server traffic between midnight and 3 a.m., which was an interesting figure. But the knock-on effect of all of this, in the main, again, there's exceptions, but in the main, most companies have said that they actually saw a surge in productivity. So productivity numbers were up during COVID-19 while people were working from home. And I suppose this was motivated by a couple of things. I suppose employees were wanting to stave off the risk of a potential layoff, not knowing whether their bosses or employers know that they're working, so putting in the additional hours, having the laptop open while breakfast, lunch, and supper, as probably most of us had. And this sort of always-on culture that we lived with for so many months, and which in some cases has worked well for companies, so much so that they're starting to relook at whether they need the overhead expense and the big leases that they do. I know that, for instance, in the insurance industry, sales, and real estate, they're looking at permanently adopting work from home type solutions. Probably something that wouldn't have happened if we didn't have the pandemic and people were forced to actually consider it. But there are some trade-offs which I think as HR professionals and business owners and even lawyers, one needs to be aware of. And that was that employee fatigue also went up. So yes, productivity has gone up, but at what cost? So these are the employees that will be coming back to the workplace. And one is certainly seeing trends where, companies are now fully reopened, I would hope in most cases. They're starting to recall most of their staff. Schools are open again. And I think employers are wanting to put their heads down and make a run for it to try and make up for lost time. But what you've got is a workforce that's returning, which are otherwise fairly spent and are asking for vacation and additional time off and so forth. So that's probably something to manage and probably something to be conscious of as we move through the great return to work. Then just how we effectively manage this as business owners and HR professionals. So again, we'll share with the Select Path team and they can distribute it to yourselves. We had prepared just a generic work from home telecommuting policy, which you can make your own and adopt as you deem fit. But it's something that you can hit the ground running with immediately, depending on whether your work from home arrangements are going to continue or whether it's something that you want to adopt going forward on a more permanent basis. And just some thoughts around that. I think that the first issue is, how does one manage productivity and how do we communicate that to our staff? I shared with you a few moments ago that I think a lot of employees were working harder because they were trying to stave off the risk of perhaps a layoff, not sure whether the boss knows that I'm working, so I'm going to send emails throughout the entire day. There were different dynamics at play for sure. So how one manages productivity and perhaps just bearing in mind that being logged in doesn't mean that you're necessarily working, but similarly, by the same token, being logged out doesn't mean that you're not. So how do we look at those things, and are there other metrics that we can use and break the mold as we move to the new world of work? And how we manage overtime. I mean, this is a big issue, especially if we're going to adopt work from home type arrangements going forward. How do we manage these sorts of things where employees simply claim that I worked an additional 4 hours yesterday? Difficult probably to manage. One will have to look at metrics and systems. And again, this will differ company to company, but just something to bear in mind. And then I think importantly, we saw during COVID-19 and the entire pandemic, and even still today, the trend over the last few years is really a new focus on data security. And this is a live issue when one looks at work from home type arrangements. During the pandemic, we definitely saw an increase in hacking attempts, and company data was more exposed than ever before. Laptops were open all over the house, perhaps in the condo that one shares with a friend, family member, and just a general lack of confidentiality. Walking out into your backyard and hearing the neighbor on their telephone or on a call, sharing information. And so I think that there was just some concerns around that, and to bear in mind how we harmonize those within our new world of work, and that certainly the telecommuting or work from home policy is one way to look at that. And then shared Wi-Fi. The amount of people that will go and get a coffee, it's obviously easier now to sit inside of a coffee store, but and use the shared Wi-Fi, or in a condominium, perhaps there's a shared Wi-Fi, and whether that's a secure connection. And then also workarounds. I spoke to an employee the other day. I mean, they said that effectively what had happened is the company had installed some sort of software which prevents employees from printing certain documentation. So this is one of the safety mechanisms that they had put in around confidentiality. But all that's happened is that employees need to work on this particular information. They can't print from home because they're locked out. So they just email the document that they're working on to a private Gmail account and print it from there. So again, just to bear in mind how these workarounds are used and how they continue to expose our data security and our intellectual property as we move to work from home type arrangements. Then I think just again on data security, I think the focus over many years has been to build the walls around the fortress. And it's all been about software and hardware and making sure that the IT department does their job to prevent us from attacks from coming from the outside. And very often, yes, if you look at history, a lot of these data breaches have been from the outside. But I think that there needs to be another focus here, because a number of these breaches over recent years have also emanated from within the organization. So from the very people who have the access codes and the key to the fortress, any slip of attention on their side certainly exposes one and one's data to these hacking and phishing type attempts. And some further considerations here, just for your telecommuting policy or work from home arrangements, would be issues around third-party software. As people are working from home, what naturally happens? Netflix is installed, Amazon Prime, maybe there's some sports that are watched on Reddit, unsecured internet sites and so forth, the dark web. These are the ways that these gremlins get into your systems and your servers. So again, perhaps just setting out rules and security protocols around that. And then also third-party technicians. When people are working away from the office and perhaps out of the big cities, I've just bought a new printer, so I need to get the printing software installed. I'm struggling with it at home, so I drop it off at the store that I bought the printer from, and they sort of assist with that. What information is readily available to the outside world? And just thinking future forward and what the world of work may look like as we move through these various things, because certainly some employees are coming back to the workplace saying, I've done this for 3 or 4 months at home. We did it successfully, productivity is up. I don't want to come back to the office again. I'm happy to stay working from home. And I think that the trend will be going forward in many cases, not all, but in many cases, that offices will probably have more sort of just generic, general meeting rooms or consulting rooms, and then probably just open offices that are undedicated, where staff can come in, work for a couple of hours, have a meeting, and then go back home. And I shared with you some of those trends. The other nice thing about work from home is if it does work for you, I suppose it may be a little bit more millennial proof. The millennial movement is certainly a growing one within the workplace, where flexibility is a big driver, not being office bound is a big driver, and these may be things to start looking for. Then the government programs, I'm just going to sort of skim through these. I think most of us know what they were, but really the focus throughout the pandemic was speed over perfection. And we saw that with a number of amendments coming through, so much so that they almost created confusion amongst sort of HR professionals, business leaders, managers, etc. And at times even amongst lawyers, because it was coming through so hard and fast that one needed to keep your finger on the pulse. And often there was a disconnect between what was being said in a press briefing and what the legislation actually provided for later on. But effectively what we had is, we know that we had ER, which was up to 55% of insurable earnings. And then we had the CERB. For those of you who have staff who have been accessing the CERB, which is the Canada Emergency Response Benefit, that paid around $500 a week up to $2,000 a month. That benefit would run for a period of 24 weeks. Again, another new update just a few days or weeks ago, that's now been extended to 28 weeks. So there's an additional period under which employees can claim the CERB. Two of the limits, I think, under the CERB, just so that you have them, is one that the CERB is a taxable benefit. So I think the sad reality is that most people who have applied and are receiving the CERB are spending the full $2,000 per month, only to have a tax liability at the end of the financial year or tax year. And the other thing is that you can't have earnings of more than $1,000 for a 14-day period. So again, this comes back to the recall issue around layoffs and employees not wanting to come back because it would kick them out of their eligibility for the CERB. We had the CEWS, which is the Canada Emergency Wage Subsidy. That provided up to 75% of salary and wages. that's had a number of changes, and it's morphed now into a sort of sliding scale, depending on your financial performance. And that sliding scale sort of tapers off down towards the bottom end. And then there was also the 10% wage subsidy, which was one of the first ones that were announced, which is still there as well. And then we also saw things like rent relief and forgivable loans. But there's 3 new programs that have come out that were just announced a couple of weeks back, which I wanted to just draw to your attention. The first is the Canada Recovery Benefit, again, another acronym, CRB. That's going to give applicants $400 per week, and that will be available for up to 26 weeks. It's typically aimed at the self-employed or workers who would not ordinarily qualify for EI. And unlike the CERB, has one benefit of the CRB is that you can still earn some money. All that one has to demonstrate to be eligible is that there's been a drop in income or revenue. So that's the Canada Recovery Benefit. The next one is the Canada Recovery Sickness Benefit, the acronym CSRB. That will provide applicants with up to $500 per week and will be available for a 2-week period. I believe that the 2-week period is probably linked to the 14-day self-isolation period, and that's probably why we're seeing that, and just employees that need to self-isolate. And it's likely going to be available if other benefits have been used up. I've shared with you some of the limitations of some of the others, but certainly there is an overlap here with infectious disease emergency leave as well. And then the last of the new is the Canada Recovery Caregiver Benefit, CRCB, which will provide up to $500 per week for a period of up to 26 weeks, but that's assessed per household as opposed to per worker. And that will provide a benefit for any worker who's required to care for a child as a result of daycare, school closures, and even care for a family member. And again, there's certainly here an overlap with the infectious disease emergency leave. So one will just have to see how all of these interact and take it from there. But again, as we've come to learn with COVID-19, change is the only constant. So where are we going? Social distancing circles, rotational staff schedules. These are some of the things that we've seen companies implement. And if you've got your workforce back, you probably would have already gone through these. If you haven't, we're happy to chat to you if you need to put some arrangements in place. But one of the most awkward things, I think, in the business environment and for any sort of company or employer, HR professional, is sort of meeting new people. Like with the world of work being back, meetings are kind of happening again, provided there's social distancing. We all wear masks indoors now. It's so awkward, I find, meeting new people. So what do? Do you reach out your hand? Because some people still want to do the old way of greeting, or is it a fist pump, or is it an elbow greeting? Is it just that awkward sort of wave? It does become difficult, and I suppose perhaps just as management and HR professionals, it may be worthwhile just sending out a circular as the workforce is coming back to work, just setting a standard of what the acceptable standard is going to be. You know, are we just going to do the elbow greeting, or are we just going to wave? It probably just takes some of the awkwardness away. And I think that's probably the best way of just dealing with it. So the great return to work, health and safety, these are just some of the issues that I think are relevant as well. Under the Occupational Health and Safety Act, we know that employers have to take every reasonable precaution in order to keep their workplaces safe. And we've seen some employers and some companies taking this even further. For those of you that are interested, WestJet in Canada, I believe, just had an issue a couple of days ago with requiring, so it's alleged, that a child was to wear a mask on board, and there was a delay to the flight. And there was also an issue at one of the Disney stores in southwestern Ontario, where companies have decided to take further protective measures over and above the bylaws around mask wearing indoors and so forth. So just something to bear in mind. And I suppose for each employer, it's up to them as well to decide whether they want to take it further than necessary. Certainly the bylaws are the minimum standards, and I suppose it's open to go beyond those. So temperature testing. Those of you who have been into certain environments, I know at a lot of the schools at the moment, when you walk in there, there's a temperature test for both you and your child, and certain other environments too. And this certainly does still remain a little bit controversial, and it's yet to be tested, I suppose, by the courts under the umbrella of COVID-19 and whether it should be permissible in those circumstances. But reliability, I think, is the key consideration here around temperature testing. And I say that because it disregards asymptomatic carriers of COVID-19, which the medical results say is quite common, where people won't show any symptoms whatsoever. They would come into the workforce, they may be contagious, but they pass the temperature test. So probably a false sense of security on that. The other thing is I think it can result in a false positive. Suppose if you live in the same building as your office, you've just jumped out of the shower, or you've jogged to work, whatever the case may be. Suppose there may be false negatives. And not to mention, the normal flu season is probably approaching us too. So one will see some of the numbers indicate positives, but not necessarily COVID-19. So I think the advice to managers and employers and HR professionals is that if we are going to temperature test, that it should just be on a preliminary basis, and it should just be an indicative tool that further testing is required. Also, how we administer it will be important. Preferably, it should be a nurse or a medical professional. Practically, it's unlikely that that's going to be the case. How records are kept. So what do we do with the records? I know that every day my temperature gets taken when I drop my daughter off at school. I don't know what's happening with those records. And it's kind of just an open table where they're left open for everyone to see, whose temperature was what. So I think that there needs to be a focus in any business or corporate environment around confidentiality and record keeping. And again, the focus here again coming in around data and security. And I think importantly, how the testing is administered and how it's witnessed. For instance, if someone takes a temperature test and is then seen leaving the building, is the perception then that that person has COVID-19? Probably. I think people will jump to those assumptions given just the sensitivity around COVID-19. So probably ensure that whatever testing is done, it's done in as confidential setting as possible with the least intrusive measures and just obviously respecting privacy and dignity and those sorts of things. I think what's more common for workforces that are returning are declarations. Again, we've prepared a declaration. I'll share that with the Select Path team. They can pass it on to yourselves. You can make it your own. Our suggestion is that's probably completed on a weekly basis prior to staff coming into the workplace. And it's just really a declaration around whether there's been any exposure and probably just the employer's due diligence around ensuring that the obligations under the Occupational Health and Safety Act are complied with. And what we've also put into ours is a positive obligation. So for instance, if I complete the form Monday morning before getting into the office, and on Wednesday I start developing flu-like symptoms, that there's then a positive obligation on me to inform the employer rather than wait for the following week when I have to fill in the next form. I have seen some employers doing these declarations on a daily basis. I think if you've got the positive obligation wording built in, you probably don't need to do it on a daily basis. And again, it's just really a step to make sure that there's better protections in place. I suppose it is difficult to police strictly, but one's working with what we've got for the time being. Then again, just discrimination issues around testing, temperature, declarations, etc. It would be our advice certainly that any of these declarations on temperature testing or any other kind of assessment tools are done top to bottom. So right the way from top executives all the way down, to your sort of entry-level admin staff, everyone would need to go through these just to avoid any perception of discrimination and certainly to stay away from any racial or gender type issues. I know that in the agricultural sector, there was at some point in time comments being made in the press that seasonal workers would only be tested, and certainly that was rearing concerns around discrimination. So just again, be conscious around those sorts of issues. And then work refusals. Again, these are going to be done on a case-by-case basis. If employees are refusing to do work because they believe that they're at risk, 3 short steps really just to investigate the matter as much as possible, try and get on top of the information, take statements and so forth. Obviously, removing the concerned employee from any risk or perceived risk. Secondly, trying to see if the matter can be resolved internally, and failing that, one can resort to the Ministry of Labour if you do have a work refusal in your particular environment. And typically, they've been adjudicating or resolving those telephonically. And if the employer can demonstrate that they've taken all reasonable steps and precautions, in a lot of cases, employees were in fact ordered back to work. So that's just another interesting one to bear in mind. And I thought just to mention here as well, just around the issue of discipline when it comes to sort of testing and health and safety precautions and PPE and those sorts of things, just to bear in mind and be conscious, I suppose, of the optics around discipline during the pandemic and as we move through things. The heavy-handed approach may work in most cases. Here it may require a bit more of a sensitive approach. So again, case by case, but one needs to just work through those and bear that in mind. The types of leave, I've shared with you some of those. I think that we've touched on most of them. The one aspect I did want to share here is that there's certainly a growing trend, and there's a lot of articles appearing online, and I think certainly some sentiment on the ground that in reality, the whole issue around layoffs and recall and who needs to use infectious disease emergency leave is predominantly falling upon women. And I think that that's probably because, sadly, globally around the world, we still have entrenched income differentials. So if I just take a typical sort of environment, the husband may be called back to work. Perhaps he's earning a little bit more than his wife. They got 3 kids at home. And so when the wife's recalled back to work, and we've worked through a couple of these issues as well, she sadly has to turn that down. The burden falls upon her. So again, that's just an emerging trend, which I thought I would share. There's some amazing statistics out there and some great articles. Something to bear in mind as you work through different accommodations and work from home arrangements. And even if work from home doesn't sit well with you, it may be necessary to consider whether that's a possible accommodation when moving through these sorts of issues, primary caregiver, whatever the case may be. And I think that was pretty much it on the leave aspect. So I think that we can move to terminations. Again, something really interesting. We've seen that during the COVID-19 period, certainly, companies have reassessed their staffing requirements. And they've re-looked at things and determined whether they still need the 20-employee sales team or whatever the case may be. And certainly there has been some terminations that have taken place during the COVID-19 period, and even now when people are returning back from layoff and so forth. And there was really just one new change, a significant change certainly, which we wanted to share with you. And again, building flexibility into the contract of employment and ensuring that we future-proof our contracts. We will again share with SelectPath just some wording around termination provisions and updating that. So any of you who've got that precedent or template contract of employment, please pull them out after this webinar and just double check your termination clauses. The case went like this. So effectively, there were two termination provisions, as you find in most contracts of employment. The first deals with a with cause termination or for cause termination, which is effectively sort of the misconduct that you would typically find. And the clause there would typically say that if we terminate you for cause, we don't have to pay you anything upon termination. The second typical clause that you would find is your without cause termination provision, which effectively says that we don't need to have a reason to terminate you, but if we do, that we will then pay you out in accordance with the statutory minimums under the Employment Standards Act. And typically that clause would limit all entitlements to the statutory entitlements that the ESA provides for. So the employee in question, there's a Waxdale decision that came out, which those of you who aren't aware of it, there's many things that have been written about it, but let me give you the lowdown very quickly. In the Waxdale decision, the employee was terminated on a without cause basis. The parties all went to court. There was a wrongful termination suit that followed, And all parties, including the court, seem to agree that the without cause termination provision was valid and enforceable. So there was no issue there, and typically that's the one that gets attacked, and it would make sense here because that's the provision that was relied upon. But what the employee council argued before the court was that the for-cause termination provision fell short of the Employment Standards Act or the statutory minimums. And in doing so, they relied on a regulation to the Employment Standards Act, which effectively says that the only time that you wouldn't get any pay upon termination is if you're terminated for willful misconduct, willful neglect of duty, or disobedience. Only under those three circumstances would the termination attract no payment whatsoever. Below that bar, you have the for cause or the common law standard, which may still constitute misconduct and generally does, but it's not one of those three categories. And in those circumstances, at the very least, ESA termination pay and entitlements would still be owing to an employee. And effectively what the employee council argued was that the termination provisions as a whole should be read collectively. And even though the clause that was not relied upon was sort of academic in the argument, it had the effect of tainting the entire termination provision. And they lost in the Superior Court. It went on appeal to the Court of Appeal in Ontario, and the Court of Appeal in Ontario agreed. They invalidated the entire termination provision, and effectively this employee was then entitled to common law notice, which any of you who've worked through terminations will know is far greater. So just something to bear in mind there. Please revisit your termination provisions. COVID or no COVID, this decision is quite impactful, and I think one needs to just bear that in mind. Trade unions, we're nearly done. I want to keep some time for questions at the end. Just some issues here. Recall around trade unions. Recall rights are typically in reverse order of seniority. The collective agreement will typically set out how that's going to look. But certainly as we move through, I'm hoping, the end of lockdown and shutdown and we get back to some level of normality, we certainly are predicting an atmosphere of criticism that will come from unions as to what steps employers did or didn't take during the pandemic, whether there was sufficient PPE, whether employers were proactive enough. So this will certainly be used as union drives going forward, I believe, where they'll leverage these sorts of things. And I think the one way to get on top of that is active communication as management, as HR professionals, to ensure that we're actively communicating with staff what we're doing, how we're putting their best interests at heart, any cleaning schedules, sanitizing schedules, making sure that these things are visible, ensuring that there's fresh PPE available, and so forth. So trying to get on top of that before the wave comes, I suppose. And certainly as we move through collective bargaining, I think in years going forward, we certainly expect to see increased demands around safety and PPE availability and those sorts of things. So probably just a bit of conscious awareness around those aspects, something coming down the line, I believe. And then just some reflections towards the end. I shared with you Rachel Mushawa's story and just what is the average employee going to look like coming back into the workplace. I think that there will be a renewed focus certainly on data security, and I've mentioned those. But in addition, I think mental health and support is going to be a big aspect going forward. It doesn't seem like we're quite out of this pandemic yet. It seems now that on an elective basis, parents could probably stay at home, or primary caregivers could stay at home in order to look after children, family members, etc. So how people are coping with those sorts of things and trying to balance that together with the deliverables that are required by just the world of work. And perhaps even looking toward things like resiliency training and diversity and inclusion and all those sorts of things. We've seen the Black Lives Matter movement. There have been a couple of things this year that have certainly impacted and are going to work their way back into the workplace. So I think these may be the softer type issues, but they're certainly issues that coexist with the COVID type consequences that we're going to deal with, and really just to convey to yourselves a consciousness around those so that we can work through those and deal with them adequately before they occur. And then, I was hoping if there are any questions, I know that there were two that were sent through, and perhaps I can kick off with those first. And just for the benefit of everyone, I'll just read what the questions were. The first one was, how long after being laid off in March do we have to bring an employee back before it is considered a dismissal? So I think, we were obviously all concerned about that September 4 date as being one concern. And certainly the time periods around layoffs would have re-engaged themselves at that point in time. So whether you had the 13 or the 35-week time period counting for you, that would have probably commenced on September 5 following that time period. With the regulation now being amended and the protections being conferred all the way up until January 2, I think we're okay for the time being. So if you've got layoffs that are still continuing, or layoffs that may still be implemented afresh, there's probably protections for employers still for some time. I think moving forward, if we get to January 2 and there's still a need to implement or continue with layoffs, certainly it would seem to me that the time periods under the Employment Standards Act and those limitations would re-engage themselves. And I think importantly, just to bear in mind that if you do have layoffs that will continue beyond that time period, is just to be conscious around the risks of a possible constructive dismissal if your contracts of employment don't have layoff language in them. So with the protection of the regulation then falling away, that will be something to just bear in mind. The second question that I received was, I'm employed with a federally regulated business and I'd like to know what we can do with an employee who refuses to come back to work and gives a number of excuses. It seems that the excuses continue to change as to why they can't return to work. And what do we do with those sorts of things? I mean, I think certainly we have seen some abuses during the COVID-19 period with the types of leave and benefits that are being provided. And one needs to try and root those out. And if there's evidence, one can obviously take action. Again, being sensitive to the optics around discipline. If there are fraudulent claims around CERB and those sorts of things, there are tip-off lines that are now available, and the CRA is seriously looking into those. But I think ideally, if one can try and bed down some of the reasons and build a paper trail around that, that would be an important step to start with. And to establish whether this employee is entitled to some form of job protected leave, I think that we would need to exclude that as a possibility first. So is there a need to look after any children? Is there a need to look after any family members? Or have you been required to self-isolate, whatever the case may be? Are you under medical investigation? And then beyond that, whether there's any other accommodations that we can make. So I shared with you the trend around women in the workplace and just the sort of entrenched discriminations and pay disparity that exists still globally around the world. Whether there's any accommodations that we can make. The Human Rights Code says that employers need to accommodate up to the point of undue hardship. So I think just from a due diligence point of view, to make sure that we can exclude any aspects around discrimination and to ensure that if there are any aspects that we try to accommodate those at least up to the point of undue hardship. And once all of those are excluded, and again, I would do this all probably by way of written correspondence that we can build the paper trail, you may get to one of two crossroads. The first being that this employee doesn't necessarily qualify for any of the formal types of leaves or accommodation, but it just continues as a simple leave of absence. And again, that will depend whether the company can continue to tolerate that. Again, companies are hoping that it's back to business and we need to get on with things. Alternatively, you may be back into the job abandonment type issue, which we mentioned earlier. And perhaps if they are at work, maybe even a work refusal. So those are just some thoughts on those two aspects. But again, it's a case-by-case scenario. And if anyone needed any help, we're around and we're happy to assist. So with that, I just wanted to thank the team at Select Path and Gord and everyone there. It's obviously fantastic and a pleasure to always speak with anyone around COVID-19 and just share some thoughts and some practical advice. And we'll certainly send through some of that free material just so that you can use it or adapt it to ensure that you can build some flexibility into your businesses going forward. So thank you so much to everyone on the line and Gord and Select Path. Thank you very much.
Thanks, Nick. Sorry, we think we had one more question on the chat.
Sure.
I
Let me
think
quickly see if I can open it. Okay, so the question is, during idle, you could not permanently lay off an employee without mutual agreement. We permanently laid off an employee based on the September 4th date, end date, and prior to the extension of idle being announced. Is there a risk of backlash when changing the employee status, who turns out was on a leave with only a letter of acceptance and not a mutual agreement? So this is such a fantastic question. And I mean, we've certainly worked through a number of these. Yes, idle is a form of job protected leave for sure. But there are going to be circumstances where, you know, companies are experiencing economic difficulties, so much so that they have to permanently lay off, COVID or not. And I think where there are genuine cases, one should still be okay in making sure that, you know, if we terminate it, provided we've paid out all the termination pay and we've ticked those boxes, I think that we've mitigated the risk. So I think that, you know, one will just have to have a look at the circumstances. I mean, I may want to just have a further discussion and get into some more detail there and find out exactly what the deals were or the details were around it. But certainly there are genuine economic reasons why one may need to look at a permanent layoff in those circumstances, regardless of the regulation and the extended protection. And I think that the courts would still uphold those, provided we've got facts that support the economic rationale behind it. A great question.
Thanks, Nick. Thank you, everyone, for attending. Hopefully everyone found it informative, as we knew you probably would. Nick is a fantastic speaker and covered a lot of ground. As mentioned at the beginning, we will have this presentation up on our site, as well as some additional documentation as Nick shared through the presentation. So thank you, everyone. Everyone be safe and enjoy the rest of your day.